Good afternoon, everyone, and welcome to the 11th edition of the Baltic Arbitration Days 2022. It's a pleasure to have all of you here. I will invite to the stage in a minute Dr. Ismail Selim. As you know, one of the themes of this conference is arbitration in Africa. Baltic states, Central Eastern Europe and Africa, you would say. You know, like Thais told me, like, I want to speak about Africa. I'm like, interestingly, interesting. But, I like the idea. And this is obviously like a huge pleasure again and honor to have Selim with us. Selim is the director of the Cairo Regional Center for International Commercial Arbitration. So whoever practices arbitration in Africa or has an aspiration to practice arbitration in Africa, and not only, including Central Eastern Europe and West, everyone knows Selim's name. I guess Selim is for the first time in Latvia and in the Baltics. He does a tour, like a small tour right now. In addition to being the director of the Sika Center, he is also actively involved in the organization which is called International Federation of Commercial Arbitration Institutions, right? These are the heads of arbitration institutions who gather and discuss their things. I was never, I couldn't be a member of this organization because you have to be at the realm, to be a head of this institution, and he's the treasurer there. But I see they have a business going on, this arbitration institution. So maybe he will tell us something, what they're up to, because they just had their meeting in Rome. And of course, he's also actively involved in the Chartered Institute of Arbitrators. So Selim is Egyptian by nationality, but as a good Egyptian, he also started, and a good Egyptian with international arbitration career, he also started abroad, and specifically he wrote his PhD in France, so he's also fluent not only in Arabic, English, but also in French. And when he was working for many years with leading Arab, I would say, would it be a good name? Law firms in Egypt, being the head of the arbitration practice. So Selim, without much ado, I invite you here on the stage, and Selim will introduce us to the topic, what is the scenery of international arbitration in Africa, with specific emphasis on Egypt. Ismail, please come here.
Dear all, dear attendees, dear colleagues, dear hosts, first, I'm very thankful for being invited here to speak in this very beautiful region that I do not know well. It's my first time to visit Latvia, and I am truly impressed of the beauty of this city. And I am particularly thankful to Kloberg Baltics and to Thais for his kind invitation, and also to Galina, who is also behind my invitation to deliver one of the keynote speeches here in Latvia. And I hope that I will be able to come back to this very beautiful region, whether in Latvia or in other countries of the Baltic region, and by then peace will be restored in Europe, and we will be in better conditions. I'm thrilled to be in your presence today and to introduce the topic that I have been asked to address by the organizers and hosts, whom I would like to thank for inviting me. I will talk to you about the very vibrant subject that is arbitration in Africa. How vibrant is it, and why would I call it vibrant? Several reasons led me to choose this word, and I would like to introduce each and every one of them to you. I will start with a focus on Egypt, my homeland, and I will then elaborate on other jurisdictions in Africa. When arbitration first came to rise as an alternative mean of settling disputes, commercial disputes, at regional and international levels, places around the world may have been reluctant to sanctify it at national level. Thus, many, or at least a few systems, their governments, their judiciary, their parliamentary, may have at first showed reluctance, if not hostility, towards this private justice that may have been seen as stripping their governments, their parliamentary, their judges of the power to determine how the disputes ought to be resolved. However, a major trick was at work, and that is, if none of those systems, parliamentary, judges, governments and jurisdiction, will relegate or at least welcome some kind of influence of something from outside in the solving of business disputes at international and regional levels, then those conflicts ought not to be resolved between players or stakeholders whose systems, each of its own, fails to recognize that the other might come into play or ought to play a role in determining their outcome. Thus begins the dilemma or conflict of diversity in legal, judicial, and jurisdictional background, which precedes any given dispute at international and regional levels between business players and relies on arbitration to reconcile them on the respective system from which they originate, to intermediate between them and recognize each other, or even better, to allow arbitration to directly play a role in those settings, subject to a subsequent control on the part of the originating legal system. In Africa and in Egypt more particularly, this was no different. I will start with the story of Egypt as a North African state that was one of the first countries on the African continent to modernize its legal and then its arbitration framework. As of 1949, Egypt had gotten rid of and relinquished the system that was of mixed jurisdictions, which in the course of the 19th through early 20th century played a major role in solving disputes between Egyptian nationals and foreigners on its territory. This incredible system of mixed jurisdictions, which are state courts, used judges from Egypt as well as from other European countries such as France, Germany, England, Italy, all by way of example, to rule upon disputes emerged between business actors on the Egyptian soil. So to recapitulate, in Egypt, at the end of starting from 1875 at least, we had two sorts of state courts. National state courts to decide upon disputes between Egyptians, and mixed courts to decide upon disputes between Egyptians and foreigners. Why am I evoking the issue of mixed courts in an arbitration conference? You will understand later. So the jurisprudence of mixed courts would come to emerge as an extremely recognized and preferred means of solving disputes, so much so that some Egyptian actors back then would use a foreign cover in their businesses, hiring a non-Egyptian national as their agent, to be allowed the solving of their disputes by those mixed courts, whose jurisdiction fell upon commercial conflicts between Egyptians and foreigners, either as individuals or juristic persons. This system emerged of a renowned Egyptian lawyer traveling through Europe to advocate for the constitution of mixed courts composed with judges from all jurisdictions, Egyptians and foreigners, to replace the system that was then yet in place, that of diplomatic solving of conflicts, which have favored the European business and individual whose conflict with an Egyptian business or individual was submitted to the jurisdiction of the relevant consulate of the European party. The mixed courts have replaced the consular jurisdictions as of 1875. Such mixed courts, composed of Egyptian and European judges, created a body of rules, principles, and jurisdiction for almost 74 years. Later, its jurisprudence or case law has been compiled, translated, and integrated into the Egyptian civil and commercial codes of the 20th century, which remained following the dismantlement of mixed jurisdictions and mixed courts, an extremely advanced and brilliant code for the solving of civil and commercial disputes, and which has in turn influenced many Arab countries, being a reformed Code Napoleon. Why would one mention the use and impact of the mixed courts in Egypt in a keynote address on arbitration in Africa? Then, for one, to signal the context that preceded the introduction of arbitration into the Egyptian legal system and its original reaction to it. If we originally mention arbitration as this new emerging form of resolving disputes in international settings and business disputes, one has to observe, however, that arbitration as a voluntary and alternative mode of resolving disputes was known of the ancient Egypt legal system, when the pyramids of Giza were first being erected. From the 4th dynasty onward, arbitration clauses were frequent, notably in fields landing contracts. 4,000 and some 500 years later, the adoption of the modern law on arbitration faced extreme resistance in the Egyptian parliament. Following in line with the nationalists who had retaken control of Egypt when the mixed courts had been dismantled, a few nationalist deputies seriously opposed to free market economy mentioned a few arbitral awards that had created a hostile feeling towards arbitration on the part of Arab countries for their partiality, arrogance, and their foreign character, amongst them the Lord Asquith, in famous award in petroleum development limited versus the ruler of Abu Dhabi. Another case, IMOC, International Marine Oil Company versus Qatar, Aramco, Saudi Arabia, and the Plateau des Pyramides, the famous exit case against Egypt, or the nationalization of Libyan petrol affairs. All these cases, of course, were lost by these Middle Eastern countries. In these awards, national laws were being systematically and erroneously excluded for being referred to and defined as primitive by the arbitral tribunals and substituted with general principles of so-called civilized nations thereafter. At the Egyptian parliament, an analogy was then made between arbitral tribunals and the repealed mixed courts, viewed as privileged and undesired following their abolishment as a matter of full state sovereignty. According to the members of the parliament, how are we going to accept again that Egyptian entities will be subject to disputes decided upon by foreign arbitrators? Further, one of the deputies of the opposition also reminded the assembly how Khedive Ismail, the ruler of Egypt in 1864, had lost an arbitration against Ferdinand de Lesseps, a French engineer, on the occasion of the abolishment of forced labor by the Khedive. Parallelly being mentioned the award rendered by the arbitrator, the then arbitrator Napoleon III, that has resulted in the forced sale of Egyptian-owned parts of the Suez Canal Company to its European shareholders. The opposition added thereto how arbitration is systematically imposed by the IMF and the World Bank. To the contrary, another deputy of the majority, this time Mr. Edward El-Dahabi, a deputy of the majority, simply stated, this was in 1994, I believe that, and I'm quoting him, I believe that if this arbitration law is adopted, Cairo and Alexandria would become seats of international commercial arbitration as Paris, London, Geneva, and New York. The law eventually came to be enacted in 1994 and was based on the UNCITRAL model law. What ensued may not have been foretold and predicted in full, and yet was anticipated by Deputy Edward El-Dahabi. The enactment of the Egyptian Arbitration Act of 1994 gave way to Egypt being chosen as a seat of arbitration in a number of disputes involving Egyptian and some African parties, along with hundreds of other Asian, Middle Eastern, European and American parties as well. This did not used to happen before the enactment of this law, and all the arbitrations pertaining to Egyptian private or public entities were arbitrated in Europe. In the years since then, the Cairo Regional Center for International Commercial Arbitration, the acronym is CERSICA, backed by a friendly arbitration environment, has witnessed a steady increase in its caseload and is now proud of having administered slightly more than 1,570 international, regional and domestic cases, most of them seated in Cairo, Egypt, and involving players originating of a plethora of industries and commercial settings. Arbitrators, having served under CERSICA rules, mainly appointed by the parties and co-arbitrators and exceptionally appointed by the Arbitration Center, came from dozens of various nationalities. By being able to negotiate a seat in Cairo or Egypt for disputes being heard ad hoc under, for instance, the UNCITRAL rules, or under the auspices of institutional rules, as may be CERSICA or ICC or any other notable arbitration institution, the particularities, concerns, and public policy requirements of the North African or Middle Eastern regions could more often than not play a role at the stage of a greater post-arbitral judicial control operated by Egyptian courts. Hence, arbitrators ruling under an Egyptian seat had to have regard to the substantive and procedural public policy rules of the law of the seat to ensure validity and maximize the chances of enforceability of their award. That said, it is time now to open onto the rest of Africa. What did arbitration do in other regions of Africa? Well, one can only look at the enthusiastic African community that works for arbitration's promotion, development, and further establishment over the African continent to assume that, far from being hostile, African stakeholders, be they governments, states, or else private actors, are looking for a stronger hold and ability of African originating actors to play a role in arbitration and exercise some kind of influence on it. Only by being part of arbitration can the African continent and the actors in it and their contextual necessities, concerns, and interests be put forward in industry, business, and commercial-led and related disputes and practices. Thus, leveling on influence is preliminary and initial reciprocity. Arbitration then being welcomed and favored to the extent required by those special settings and actors that we have earlier described as international and business pertaining by states, their courts, and legislations. The necessary trust of other involved allows for the state, their courts, and legislation being recognized a degree of control and supervision through the choice of the seat. On the level of African states, 42 out of 54 have already ratified the New York Convention on Recognition and Enforcement of Arbitral Awards. 11 African states have enacted arbitration laws based on the UNCITRAL model law. The first country among those 11 being Tunisia, as early as in 1993. One should fairly add to those 11 states another 17 states of the West and Central Africa forming part of the Organization for the Harmonization of Corporate Law in Africa, which is called OHADA. Indeed, the Uniform Arbitration Act of OHADA, as revised in 2018 and applied by its 17 member states, is also based on the UNCITRAL model law. The foregoing is not all the inventory of reformed arbitration laws in Africa. Indeed, some African countries like Algeria have enacted an arbitration law based on the French model, while others, such as Tanzania, have enacted an arbitration act based on the English Arbitration Act of 1996. That said, I would like to share with the audience another success story of arbitration on the African continent. That is the story of Rwanda, which is a beautiful and modernized sub-Sahara African state located in the eastern part of Africa. Indeed, in 2003, Rwanda's courts had a huge backlog of cases as the country struggled to seek reconciliation following the terrible genocide that has occurred in 1994 during the Rwandan Civil War and has cost the lives of almost 1 million of the people of Rwanda. Turning the page after such extremely sad events, Rwanda was aiming to develop and attract greater foreign investments and increase investors' confidence. Therefore, a commission was established to look at the question of commercial justice and how to ensure the backlog of cases through the Rwandan courts did not affect investors' access to justice. In 2007, efficient commercial courts were established, followed by the enactment in 2008 of a new arbitration law based on the UNCITRAL model law. Rwanda also ratified the New York Convention. The aim was to ensure that commercial parties in Rwanda would be able to access an alternative way to resolve their disputes. In 2010, the Rwandan government passed an act of parliament establishing an independent body tasked with promoting Rwanda as a venue of efficient arbitration services and a center of excellence for research and training of professionals in ADR. That independent body was to become the Kigali International Arbitration Center, KIAC. The latter was an amazing success story backed by a friendly arbitration framework and an investor-friendly environment. KIAC's caseload in only a single decade approached or stands at almost 200 cases involving parties coming from more than 20 countries, located in 4 continents. KIAC reports that not a single award rendered under its rules has been set aside until now. Another example of a country that has taken such a step in becoming a more arbitration-friendly seat is Mauritius, through its enactment of an UNCITRAL model law-based legislation in 2008 and organizing extensive training courses on arbitration for its judges. Such efforts culminated in the choice of Mauritius in 2016 as the host of the first ICA Congress to be held in Africa. Indeed, arbitration taking place in a given seat plays a major role in the development and welcoming of businesses and operations in the relevant country. According to several French scholars, an arbitration market does exist. The wave of modernization of arbitration laws has been coupled with policies aiming to attract arbitration on national soils. Conducting arbitral proceedings and holding arbitral hearings on a certain territory is a source of revenues for the lawyers, experts, interpreters, and arbitration centers. It also boosts the economy in general. It boosts transportation. It boosts restaurants and hotels. There is a true economy behind arbitration, being a branch of the business tourism. That is why France, through its pro-arbitration judiciary, has aimed at maintaining Paris as one of the most preferred seats of arbitration. whether before reforming its arbitration laws or thereafter. On the human level, skilled African arbitrators justifiably feel underrepresented in African-related cases, despite the efforts made by the major arbitral institutions to promote geographic diversity in appointments of arbitrators. By way of example, the ICC statistics of the year 2020 reveal that 6.8% of the 929 new cases involved African countries, but from among the 1,520 appointed arbitrators, only 2.3% came from African countries. The good news that Diamana Diawara is going to tell us that in 2021, the statistics shows much more diverse appointment of the ICC of African arbitrators. So this shows that institutions are carefully looking into this matter and promoting geographic diversity in appointment of arbitrators, including African arbitrators. Another example of the problem of lack of diversity, despite the efforts of the institutions, can be taken from the LCIA statistics of 2020, where 444 new cases have been registered, but only 14 arbitrators came from African countries. Further, this would be the last example, SIAC. SIAC has reported that it has registered a record of 1,080 new cases in 2020, among which 41 cases involved African states. Yet, only a single African arbitrator, from Nigeria by the way, has been appointed in that year. So the institutions are not to be blamed. Also, the parties are encouraged to objectively consider appointing talented and well-versed African arbitrators. From among the various initiatives supporting arbitration on the continent was the establishment of the African Arbitration Association, and I am honored to be a member of its board of directors. The AFAA. The AFAA aims to promote African international arbitration practitioners and African arbitration institutions within and outside the African continent, and to facilitate and encourage the appointment of African international arbitration practitioners and the use of African arbitration institutions. By and large, enhancing gender, geographic and institutional diversity would increase the legitimacy of arbitration and strengthen the rule of law. Thus, to conclude, and I hope I'm respecting the time afforded to me, I need about 2 or 3 minutes, plus a small surprise for the audience. Thus, to conclude, what, if not vibrant, is the subject of arbitration in Africa? Africa and arbitration have yet much to learn from each other, but they have, up until now, helped actors originating from all over the world handle their disputes in a constantly evolving setting that is international commerce and its relating transactions, industries, and actors, as have been taking place within, between, and over the African continent. Here comes the end of my keynote speech, but still there is a surprise, and I thank the organizers for letting me share it with you. It is a 1.5-minute trailer of a documentary that was produced by Corsica, by the Cairo Regional Center for International Commercial Arbitration, to celebrate its 40th anniversary. However, due to the pandemic, we were not able to show this documentary. We are not going to show it today. It is reserved for a major event in Egypt, in Sharm el-Sheikh, in December, during the first week of December, but we will show you the trailer. Perhaps you will be interested to travel from the Baltic region to Sharm el-Sheikh and the name is Between North and South. So we are here at the North, and we invite you to come to the South and watch it. It's a documentary that we have produced and created by Escape Home. That is the people who have directed this documentary. It tells the story of how agreements to arbitrate have supported the economic growth of the Afro-Asian region. The idea is that without the arbitration clause, all the development projects would never have taken place because arbitration is the most suitable means of settling disputes, if any, between parties from different countries. So I would be very thankful to the organizers if they can show us. It's a 1 minute and a half trailer, and I hope you will like it. And I thank you all for your kind attention.
Foreign trade is the key to prosperity. Free trade will bring on a Great Depression.
A high tariff policy will lead to war.
Long ago, the world was divided into East and West. The West symbolized advancement and prosperity, while the East became associated with backwardness and poverty. But this view is certainly out of step with today's reality.
Why East Africa is the fastest growing region in Africa.
Kenya and Ethiopia on the verge of overtaking Nigeria and South Africa as Africa's economic giants.
Southeast Asian countries are emerging as major players in the global economy.
Countries in Africa and Asia are undergoing a transformation, and the face of many of these nations is changing. But as trade grows, so do international trade disputes.
One could easily foresee that there will be more trade and naturally more disputes to be settled.
This is the story of the people fighting to resolve disputes through a field of law known as international commercial arbitration.
Being exposed to international arbitration is not something you can avoid.
One of the most efficient means of dispute settlement is arbitration.
Arbitration always has been existed.
Arbitration has played a significant role for society and for growth.
ما يتميز به التحكيم هو المرونة وكذلك السرية.
Over the years, it has helped establish the foundations of commerce in the Afro-Asian region.
Afro-Asian relations are destined to solidify in the future.
But today, these nations are reaching a new stage in their economic evolution.
Asia is playing a major role now, investment and trade role, probably the primary role in all of Africa.
Some nations are becoming true superpowers.
That China has become the second largest economy in the world.
All the Africa of 10 years ago is not Africa of today.
Will international arbitration be able to keep up?
Asian African countries start to have a say in international relations.
I do remember. Well, this was a wonderful start of a conference, right? Thank you so much for this presentation. I still would like, when in time, I think we can ask a few questions to Selim, to Ismail, sorry. Would there be any questions from the audience? We have a question, number one.
Yes.
I've heard it said that African lawyers charge fees of up to $700 per hour. Would that be a reason why there are so few African arbitrators?
700. This kind of fees is also charged, I can say, about Egypt, because I know Egypt better. At the time where I was still in private practice until the end of 2016, partners would charge this amount. But I think that the fact that they are not appointed as arbitrators is not because of their hourly rate. I think the international community, it's like appointing female arbitrators. We were not used to appoint female arbitrators at the beginning, and then the habits are changing. So I think that by getting used to appointing arbitrators from the sub-Saharan country and from North Africa, gradually this will become a normal way of acting. Yes.
May I just ask here a related question? Like the Cairo Regional Center for Commercial Arbitration, you operate on, like you have scales for dispute, or you work on an hourly basis?
No, it's ad valorem.
Ad valorem. So, for example, like one of the centers. Thank you, Ismail. Any other questions? We have one more question. Aya.
I do. So the one word would want to develop practice in Africa. What connections are important for African disputes? Would it be government officials? Would it be colleagues in African law firms and practitioners? Would it be directly businesses? Like, what do you think is the best approach to doing that kind of thing?
I think both the governments and the local law firms. I think if you want to develop the practice in Africa, it's the government. The government uses foreign lawyers for major arbitrations, and also to have contacts with, to co-counsel with local lawyers.
And including, I think, lawyers who were featured on the video, right?
But there are also your own investors. Your own investors can open the gate for you to support them in their, while they're investing in Africa.
Any other questions? Could you please present yourself? Sorry, I haven't asked to do it before when you ask a question. Niels?
Niels, my question is, do you have any statistics whether African parties who are represented by African Council are more likely to appoint African arbitrators than is represented by international firms?
Usually African parties are not always represented by African lawyers. They are usually, especially in the major arbitrations, they would be usually represented by firms established in Europe or in the United States. And it's legitimate, they want to win the arbitration. So usually a party, if the arbitration is very complex and very big, would first rely on an experienced law firm wherever it is located. So if I speak about our experience, at least as Egypt, Egypt has relied upon law firms located in Europe, so major international firms, but has gradually relied, at least partially and sometimes fully, on either the state lawsuit authority, which has gained a lot of experience because Egypt is the third most sued country, at least under ICSID rules, because it has 74 BITs still in force. Also there is a reliance on Egyptian lawyers, but all this comes gradually. And so I do not suggest that that suddenly we will be only relying on African lawyers and African arbitrators. As I have mentioned in my speech, the mixed courts were very useful to us for 74 years to the extent that it permitted us to reform our Napoleon Code that we had adopted in 1875. So we need the European and American experience or Asian experience whenever it exists. But the idea is to promote diversity, whether in arbitral appointment or in council appointment, and this should come gradually and steadily.
I think we have set out an excellent ground for the discussion and conversations outside this room, including. So I would like to thank Ismail for a wonderful presentation. I invite you to ask him questions during our coffee break, which is about to start now. A coffee waits for you outside. One more point, which Thais asked me not to forget. If you would like to see bird's view of Riga, and I'm sure you want to do it, you're invited to take lifts up to the, to go up. And for this, please approach people at the reception, like people at the registration desk, and they will lead you, where to go and which lifts to take. And let's try to be here, let's say 20 past 3, I have use my power as a moderator of this session, and we'll continue our keynote speeches. Thank you so much, and enjoy your coffee break and the bird's view of Riga.
Thank you.